feeling of sorrow and remorse.
His kids love him so much. Be fair.
I'm seeking the death penalty. It's a comfort.
It's not been easy, but I want you to know that you are.
Charles Reeder, who was once seen as a kind of modern-day Robin Hood, faced 18 charges, including engaging in a pattern of corrupt activities and tampering with records. He had previously held the highest rank in Pine County law enforcement as the sheriff. A year after his tenure, he gained national attention during the investigation of Ohio's most notorious homicide case, the 2016 Roden family massacre, where 8 family members were brutally slain. The investigation eventually led to the arrest of 4 members of another local family, the Wagners, 2 years later. Throughout this time, Reeder was frequently in the media, praised for his effective handling of substance and gang-related crimes.
We declared war on drugs when I was appointed the sheriff in 2015. We came together with the Piketon Police Department, the Waverly Police Department to form a major drugs and crimes task force. And the reality is, after the alert that I put out, people were shocked that there was gang affiliation coming to Pike County.
However, Charles Reeder's reputation soon took a dark turn. Just a month after the Roden family case concluded, an anonymous tip about questionable salary and benefit collections in the sheriff's office led to a state raid. The investigation revealed far more troubling activities. It was discovered that cash envelopes had been tampered with and impounded vehicles were auctioned off at exceptionally low prices, only to be resold at more than double the price. The orchestrator behind these deeds was none other than Reeder, who was the town's favored sheriff. Investigations showed that Reeder had a gambling addiction and had used his position to finance this habit, incurring debts with deputies and a car dealer. Despite his claims of being framed, Reeder resigned from his position and was indicted on 23 charges. When served with the indictment papers, he cursed at the deputy and later pleaded not guilty in court.
Hey, sir, how you doing?
It'd be better if you get my property.
Understood. There you go, sir.
Despite initially vowing to fight the charges, Reeder changed his stance a year later, pleading guilty to 5 charges, including theft in office and tampering with evidence. During his court proceedings, several individuals testified on his behalf, arguing that the pressures of his job had overwhelmed him and contributed to his unlawful actions.
A greater man than Charlie Reeder.
Judge Patricia Cosgrove listened closely as the defendant made a lengthy and emotional plea for leniency.
As a sheriff of Ohio, I shed, I shed bad light on the office of sheriff. I can only ask that my staff, their families, the community, and my family who is here today will forgive me for the undue stress I caused them. For this, I am terribly sorry. I stood in this court on September 24th and pled guilty to the charges against me, to accept responsibility for my conduct. I have, and I now pray that the court will find mercy on me. And I beg the court, if they see fit, to grant me community control, even with the strictest sanctions that I have proven to this court in the past 2.5 years.
But before he could take his seat, the judge had some questions for Reeder.
I have a couple of questions for you. The big question I have, and is on everyone's mind, I'm assuming, is why did you cut open these evidence envelopes and take the money out, and then in some cases you put it back, although you were caught because the envelopes had been unsealed and sealed again improperly, and the denominations did not match what was taken at the crime scene or from those individuals. I guess, why did you take the money?
Reeder attempted to justify his actions by claiming he was like a modern-day Robin Hood.
The money, and mind you, this does not excuse it, but from drug dealers that took it from parents of very poor people in this county. That money, regardless of what the state and what the media has claimed in the past years of a gambling problem and that money being used for gambling, was used when there was a tree planted in the name of the Shelton boy. It's at the entrance of Western High School to the left as soon as you pull in. Nobody could pay for that tree. Nobody offered to pay for that tree. A drug dealer did.
But no paper trail showed Reeder had supported a single cause.
What you're saying here as to why you claim you used the money for various charitable community things, and then, but the PSI officer notes that there's no documentation that you used it for those things.
His responses failed to convince Judge Cosgrove of his remorse, and she had little sympathy for someone who had betrayed the badge and broken public trust. As the judge sentenced him to 3 years in prison, Reeder's wife and children cried. He was then escorted out of the courthouse and taken into custody by the deputies he once led. Now, let's turn to the Lake County Common Pleas Court, where the judge is handling the case of Kevin McCarthy, a former Cleveland firefighter who fatally wounded his roommate in April 2022. What will the verdict be, and how will McCarthy react to his sentence?
911, where's your emergency?
I'm out front.
Okay, what's going on?
I accidentally discharged a fire alarm and I accidentally my roommate.
Okay, does he need an ambulance?
Oh, he's dead.
On April 14th, 2022, around 10:15 p.m., police received a call from Willow Grove apartment on Grove Avenue. The caller, Kevin McCarthy, reported that he had just harmed his roommate, 25-year-old Christian Kilberg. According to Geauga County prosecutor Carolyn Mulligan, the two men had returned to their apartment after a night of drinking. While possibly intoxicated, they began to play around with a weapon without checking if it was loaded. McCarthy, holding the weapon, pointed it at Kilberg's temple and pulled the trigger, ending his life instantly. McCarthy immediately called 911, and police arrived shortly after to arrest him without incident.
Dashcam video shows Willoughby police officers arriving on scene, where McCarthy was already on his knees.
After his arrest, Kevin McCarthy was indicted in August and charged with reckless homicide with a weapon specification. At his trial, McCarthy initially pleaded not guilty, but on January 18, 2023, he changed his plea to guilty. McCarthy, who had joined the Cleveland Division of Fire as a firefighter in 2021, resigned from his position the same day he pleaded guilty. His sentencing hearing was set for February 22, 2023. On that day, McCarthy appeared in court with ashes on his head for Ash Wednesday. Before the judge imposed his sentence, he was given the opportunity to address the courtroom and delivered a tearful apology.
With every beat of my heart, it is a beat of sorrow and remorse. I simply cannot explain the angst that is now ingrained in my DNA. Budge is a soulmate of mine, and I would never intentionally hurt him or any of his family.
Christian Kilberg's mother also spoke in the courtroom, expressing her deep pain and sorrow over her son's death.
The room looks a whole lot different than a church, doesn't it, Kevin? One here is to condemn, and the other is to save. It's Ash Wednesday today. What you did was the gravest sin of all. You killed my son.
McCarthy was ultimately sentenced to 6 years in prison for the death of Christian Kilberg, 3 years for the reckless homicide charge, and an additional 3 years for the weapon specification.
I have considered all aspects of 29-29-11, 29-29-12, and 29-29-13. And as you know, with the firearm specification, it's a 3-year mandatory prison sentence. And on the underlying offense of reckless homicide, I'm going to impose a sentence of 36 months in prison.
McCarthy appeared visibly remorseful as he learned his sentence. Marcus Eberhardt and Howard Williams gained notoriety for a disturbing case. Taking the life of a man simply because he was too tired to walk might sound unbelievable, but that's exactly what happened. Eberhardt and Williams were each charged with murder, involuntary manslaughter, and 6 counts of violating their oath as public officers. On April 11, 2014, police responded to a 911 call at an apartment complex involving a domestic dispute with Gregory Towns Jr. When Towns saw the police, he fled into the woods with the officers in pursuit. Tragically, Towns never emerged from the woods. His family later discovered that he had been tased to death by the two officers. Despite being handcuffed, out of breath, and having rolled down an embankment, Eberhardt used his taser on Towns 10 times.
Shock time of 47 seconds.
While Eberhardt used his taser 10 times, Williams used his 3 times. It took over a year for both men to be indicted and charged in connection with Towns's death. During the trial, the defense argued that Towns's death was more due to his medical condition and that the officers were justified in using their tasers. However, paramedics and neighbors testified that Towns was already compliant and that the use of tasers was unnecessary.
Did something in this case that should have never been done. And so it was important to our office to restore confidence in our criminal justice system, to let people know that if you are doing the wrong thing, that the system applies equally to everyone, to police officers as well as civilian defendants.
After a day of deliberations, the jury reached a verdict. Eberhardt was found guilty on all charges, while Williams was convicted of the lesser charges of involuntary manslaughter and reckless conduct. Before the judge decided on their sentences, Towns' girlfriend, Aisha Smith, holding her 3-year-old son, spoke about her regret for making the 911 call.
Calling the officers that day, it made the whole situation worse.
You carried a lot of guilt.
I carry a lot of guilt to this day.
When Williams had a chance to speak, he apologized to the family. However, Smith wasn't receptive and lashed out in court.
Extend my condolences to the Towns family.
Nobody killed her. Nobody killed her.
She was promptly ordered out of the courtroom and then spoke to reporters.
I don't want to hear anything he has to say. I just really don't want to hear anything he has to say. Gregory's not here to respond for himself, so I did it for him.
Eberhardt was sentenced to life in prison with the possibility of parole, while Williams received a 5-year sentence. After receiving a surprisingly lenient sentence for a serious crime, you'd expect Sheriff Todd Pate to show a bit more humility, but that wasn't the case. Facing 9 charges, including first-degree assault, operating a motor vehicle under the influence, and 4 counts of wanton endangerment, Pate was caught in a troubling situation. On March 8, 2019, a 911 call reported a driver had fled the scene. Officers later found Pate in the woods near a damaged truck, trying to hide beer bottles. He was clearly intoxicated. His breath smelled of alcohol, his eyes were bloodshot, his speech was slurred, and he could barely stand. This wasn't his first DUI arrest. In 2015, he had been fined $800 for a similar offense while serving as sheriff. This time, however, he faced multiple charges and a dramatic fall from grace, especially since he had once appeared on Oprah for his exemplary police work. Pate agreed to a plea deal for a 75-day sentence in exchange for a guilty plea, thinking it would be straightforward. However, during the hearing, Judge Janet Crocker noticed that Pate was distracted and not paying attention as she began addressing the court.
Is that your phone, Mr. Pate?
Yes, it is.
You need to put it away.
Okay. I was just had a...
You need to put it away.
Okay.
Instead of pleading guilty, Pate started questioning the judge.
Your desire to change your plea from not guilty to guilty.
Do I have to answer that yes or no, or can I make somewhat of a statement?
That is a yes or no answer, sir.
Will I have the opportunity to say anything further?
If it is your intention to change your plea from not guilty to guilty, then I will take your plea, and certainly you'll have an opportunity to make any statement that you want to make. But if it is not your intent to enter a guilty plea at this time, then I'm going to set your case for jury trial, and you're going to stop wasting my time and everybody else's time this afternoon.
Ma'am, I'm not trying to waste your time.
Then is it your intention to enter a guilty plea at this time or not, sir?
No.
Judge Crocker ignored Pate's outburst and continued speaking with the prosecuting attorney.
Your Honor, we would move to revoke the defendant's bond at this time. We took part in a lengthy mediation. We agreed to continue this case 2 months to enter this plea today. I think we've inconvenienced the entire court system by canceling the pretrial date and continuing this matter for 2 months for him to resign from office. So we moved to revoke the bond.
He would be taken back to jail if he didn't decide, but Crocker gave Pate another chance.
Giles, would you like some additional opportunity to meet with your client this afternoon before we proceed at this time?
I don't believe it'd do any harm. I'll make it very, very quick. I know we've already delayed the court, and I'll report back within a couple of minutes.
Right, I'll give you another 10 minutes for that.
All right, thank you.
Thank you.
10 minutes later, the court resumed, but Pate was still insisting on being allowed to contest the first-degree assault charges.
Say a few things, or...
I need to understand what it is that we're
I would
doing
just
here
like for
today,
the
Mr.
court-
Pate.
Yes, I had every intention of coming in here today and entering a guilty plea based on the mediation that we had. It's very difficult for me to enter a guilty plea to felony-related charges that I've been in law enforcement for 25 years, and never have I ever charged someone with felony charges on a situation pertaining to this that was similar to this.
And boy, did he talk. At one point, his lawyer had to step in and explain why Pate should remain silent.
I may interject. Just if you intend not to enter a plea, don't say very much about the case, because what you say here under oath will be used against you.
But Pate kept going on and on.
Difficult for me to enter a guilty plea for a lot of reasons, and I don't want this court to think that I am trying to minimize, take away from, or deflect any responsibility that I had in this situation that occurred. I do absolutely feel like that because of my bad decisions, this whole case took a turn that it wouldn't have taken had it not been the Breckinridge County Sheriff.
Judge Crocker decided to refocus the proceedings.
I think we are back, Mr. Pate, and probably should have stayed in the place where we started.
But this chatterbox wouldn't take a hint and even started making jabs at the prosecuting attorney.
Everybody in this room wants this over with. And if I could address Blake, I hope you learn from this case I'm not mad at you. I'm not in any way upset with you.
Mr. Pate,
not that it
we
matters.
have reached that point now.
Okay.
This is either a yes or no. Are you going to enter your plea or not?
I guess everybody thinks it's funny.
Certainly not the people who I think are here with you today, Mr.
No, they don't. I've broken everybody's heart. But it's hard for me when I see Mr. Chambers sitting over there smiling. Let me just plea and get it over with for everybody. Plea to something that I absolutely do not feel good about, but I don't want you to try to send me to the penitentiary for years.
But the judge's patience with Pate was exhausted.
I think we're done. At this point in time, I think we're done. And so let me tell you where I think we are today, is that we have executed plea documents. Whether or not Mr. Pate has the right to withdraw his plea, now that he's executed those plea documents, remain to be seen.
He was taken to jail and held without bond. After some time, Pate eventually pleaded guilty and served his 75-day sentence, with credit for the time he had already spent in jail. Next, we turn to the DeKalb County Courthouse in Georgia, where Richard Merritt, a disgraced lawyer, faced a dramatic turn of events. Merritt, who was convicted of murdering his mother on the same day he was scheduled to report to jail for an unrelated conviction, was charged with malice murder, felony murder, aggravated assault, and possession of a knife during the commission of a felony. Taking the stand in his own defense, Merritt described the incident as a day of unimaginable violence, claiming that he saw two armed men took the life of his mother in front of him. He expressed his love for his mother and emphasized her support throughout his previous legal challenges.
Your Honor, I realize the words aren't going to adequately convey what has occurred throughout the past week and the previous several years. I was raised right by two very good people, beautiful people, my mother and father. I had a beautiful family that I've lost. I've long since lost them. I've lost them in the Cobb County case.
During cross-examination, prosecutors challenged the credibility of Merritt's account. They highlighted his failure to contact the police during the incident and his subsequent flight from the city. Despite his strong denials of involvement, Merritt was convicted after a 4-day trial. Upon hearing the verdict, Merritt showed visible emotion, bowing his head and rubbing his eyes as he grappled with the outcome.
Jury find the defendant guilty. As of count 3, felony murder, we, the jury, find the defendant guilty. As of count 4, aggravated assault, we, the jury, find the defendant guilty. As of count 5, aggravated assault, we, the jury, find the defendant guilty.
The murder took place on the day Merritt was set to start a 15-year prison sentence for embezzling from his clients. During the sentencing hearing, a family member passionately denounced Merritt's deceit and his attempts to evade prison. Merritt's defense attorney, unsurprised by the verdict, admitted that they did not believe Merritt's version of events. Merritt's older brother, in particular, found it hard to forgive him for their mother's murder. In the end, Richard Merritt was sentenced to life in prison without the possibility of parole. This case involves Joseph Norris from Babylon, a former New York City firefighter facing charges for causing the death of a high school teacher while driving under the influence. On November 20th, 2020, at around 7:30 p.m., Norris, who had been leaving a strip club, drove 3.5 miles in the wrong direction at 62 miles per hour. He collided with a 2007 Mazda CX-7 SUV driven by 44-year-old Antonio Mariano, who was out picking up dinner for his family. Norris was heavily intoxicated, with beer cans and a bottle of whiskey found in his 2008 Chevrolet Colorado after the crash. Other drivers had attempted to avoid the erratically driven vehicle, but Mariano, a teacher at Benjamin N. Cardozo High School in Bayside, Queens, was unable to react in time. Mariano was pronounced dead at the scene, and Norris lost both of his legs in the collision. A blood test showed Norris had a blood alcohol content of 0.29, 3 times the legal limit. The former firefighter, who had been with the New York Fire Department since 2006, was suspended with pay following his arrest. He faced charges of aggravated traffic homicide, second-degree involuntary manslaughter, and aggravated drunk driving, to which he pleaded guilty. His sentencing, set for July 19, 2023 at Suffolk County Court, was charged with a motion as supporters of both Mariano and Norris gathered. Judge Stephen Braslow delivered a stern condemnation of Norris for the fatal drunk driving incident.
Have an honorable profession. You were a firefighter. You gave your life to help people, to save people. But yet, it appears that all your actions were involving alcohol and parties and going out.
Judge Braslow further criticized Norris, emphasizing how his drunk driving had resulted in the death of an innocent person. Meanwhile, Norris visibly struggled to control his emotions.
For you to be going the wrong way for 3.5 miles or 4 miles, and people trying to stop you, State Trooper almost got to you. They almost got to you before you killed this gentle soul.
Despite his stern condemnation, Judge Braslow expressed sympathy for Norris's family, particularly noting that Norris's wife was 7 months pregnant at the time of the crash.
I have empathy and sympathy for your family. Not much for you, Mr. Norris. I'm sorry to tell you.
Just before the judge handed down his sentence, he provided some advice for Norris.
Some things in your life to make amends for this. I don't know how you're going to do it, but you really need to search your soul.
In the end, Norris was sentenced to 5 to 15 years in prison for aggravated vehicular homicide and manslaughter. As the judge delivered the verdict, Norris's hands shook and he struggled to hold back tears. In the Shiawassee County Circuit Court trial, Mark Latunsky, a 50-year-old from Michigan, is facing serious charges for the murder and mutilation of Kevin Bacon. Presided over by Circuit Judge Matthew Stewart, the case is known for its horrifying details. Bacon's body was found hanging from the ceiling days after he went missing. The crime involved stabbing, slashing his throat, and even cannibalism, which has caused shock and distress in the courtroom. The gruesome nature of the crime and the deep sorrow of Bacon's family have made this case particularly unsettling for everyone involved.
Usually you as parents are the first to go be with Jesus. But because of someone who decided to take our son's life, that isn't the case for us. Only 25 years old and had a great career as a hairstylist and hadn't been able to graduate from U of M in psychology, even though they were kind enough to honor him his degree. Such a short life for our son who had a lot to do in this world still.
If the situation wasn't already heart-wrenching enough, Jenny Bacon, Kevin's sister, took the stand to deliver her impact statement.
December 24, 2019, it was the last time I saw my brother Kevin alive. I had to wait 3 long days to learn of Kevin's murder, unaware to me that he was killed on Christmas Eve night. Kevin meant the world to me, and I will never have another brother like him. The day I learned of Kevin's death, a part of me died with him because he was my first best friend, brother, and protector. Kevin was my protector from cruel people who didn't understand me like he did because of a disability that I was born.
After the impact statements, Mark Latunsky stood motionless and remorseful as his defense attorney spoke. When it was time for sentencing, the judge highlighted the premeditated nature of the crime, noting that Bacon's death was part of Latunsky's deliberate plan. The judge then sentenced Latunsky to life in prison without the possibility of parole. In Multnomah County Circuit Court in Portland, Oregon, lawyer Lori Devaney was sentenced for defrauding 36 clients over an 18-year period. Devaney expressed remorse for her actions, stating that she never intended to cause harm and deeply regretted the additional pain her actions caused her clients. She acknowledged that she had strayed from her professional duty to assist her clients, resulting in them suffering due to her misconduct.
To all the victims who came to me in physical or emotional pain, who shared their stories and their lives with me, I can only tell you how sorry I am that instead of helping you, I inflicted more pain.
During the sentencing, Circuit Judge Jerry B. Hodson highlighted the severity of Lori Devaney's crimes, emphasizing the breach of trust and the significant impact on her victims. Testimonies from 25 of Devaney's clients detailed the severe consequences they faced, including financial ruin and a loss of faith in legal professionals. Devaney, disbarred and recognized as having committed one of the worst frauds in the state bar's history, was sentenced to nearly 8.5 years in federal prison. Prosecutors had sought a 20-year sentence, as Devaney admitted to stealing $1.8 million from 36 clients, with a total estimated loss of $4.6 million, impacting around 135 victims. Victims expressed a range of emotions, from foolishness and depression to feeling hopeless, and requested that Devaney not benefit from her story or offer legal assistance to other inmates, suggesting a minimum of 4,000 hours of community service. However, when leaving the courtroom, this happened.
Kyle Aboshi, KGW Channel 8. You care to apologize to your victims?
I've already done that in court today. I have nothing further to say to you.
You care to apologize to the legal community here?
Lori Devaney, after being sentenced, received a 14-year prison term for defrauding her 36 clients. This sentence reflects the severity of her crimes and the significant impact on her victims. In the Florida court case involving Nicholas Stevens, the attorney faced charges of embezzlement for misappropriating over $500,000 from foreclosure transactions. The case involved at least 49 victims who were affected by his actions. Stevens was sentenced to prison for his crimes.
An order signed by the court, get a check, and pocket it. And the claims are in excess of $1 million. There were at least 49 or 50 victims.
During his sentencing hearing, Nicholas Stevens expressed deep remorse for his actions, attributing them to personal struggles with depression following his divorce. He admitted to acting out of greed and leading a deceptive lifestyle, and he thanked the court for allowing him to spend Father's Day with his daughter before his imprisonment. His defense attorney highlighted that Stevens had accepted responsibility and was facing the consequences of his actions. State Attorney David Scholson noted that while the embezzled amount exceeded $1 million, most victims found the sentence fair. The Florida bar responded by revoking Stevens' license to practice law. Although the exact whereabouts of the stolen funds remain unclear, Stevens was sentenced to 10 years in prison. In the Wilson County court trial of Mark Benavidez, a former San Antonio lawyer, he faced serious accusations of trafficking and exploiting women. Benavidez was accused of engaging in intimate acts with clients in exchange for legal services. During the trial, a woman testified that Benavidez coerced her into intimate acts under the pretense of payment for his legal help. This testimony shocked the courtroom and left the jury in disbelief. Prosecuting attorney Meredith Chacon warned that more victims and disturbing videos would be presented during the trial, but urged the jury to stay focused on uncovering the truth and delivering justice.
It says to all of the women who've been affected by Mr. Benavidez that they matter, and I think that is an important message to send.
But his wife begged for mercy instead.
His kids love him so much. Be fair.
And why do you think they should do that?
He doesn't deserve this. He's a good person.
During the trial's early phase, 6 women testified about their experiences with Mark Benavidez. They revealed that he had recorded their encounters at a downtown motel, using their legal issues to manipulate them. Their accounts showed how Benavidez misused his position as an attorney. After being convicted on 6 counts of continuous trafficking of persons, Benavidez was taken into custody and sent to Wilson County Jail for the remainder of his trial. As the trial continued, more women came forward with similar stories of being coerced into intimate acts by Benavidez, describing how he would pick them up and take them to motels or even the courthouse for his pleasure. These accounts consistently showed a pattern of manipulation and abuse of power. Throughout the trial, Benavidez remained unemotional, despite the mounting evidence against him. He was ultimately sentenced to life in prison without the possibility of parole. Keeson Wilkins was arrested in April 2004 after a violent incident, facing charges like felonious assault and illegal weapon possession. He was initially convicted but won an appeal due to inadequate defense, leading to a retrial. During this retrial, Wilkins decided to represent himself, which led to various disruptions. He frequently shouted about unrelated topics, including lynchings, causing the judge to clear the courtroom multiple times to keep order. In a notable incident, Wilkins pretended to have a heart attack during a police officer's cross-examination, apparently trying to delay the trial.
Informed me that she had family in another part of Ohio.
She did not provide me with that information now.
She never provided with you. Excuse me, hold on a second. Your Honor, excuse me for a second. I need some time.
We're going to take a break. Ladies and gentlemen, if you'll please step out. The record should reflect that the defendant is slouching over to the side and acts like he's sleeping. His breath appears to be quite normal. Doesn't appear to be labored in any way. Is that a fair assessment, sir?
Yes.
It's not labored in any manner.
Yes, Your Honor.
Does he appear to be doing anything to you other than sitting in that chair?
No, Your Honor.
Oh, a remarkable change. Thank you. Anything, Mr. Thompson? Mr. Wilkins, do you have any questions for this witness, sir? I'll take that as a no, sir. Thank you, sir. You may step down. Anyone else you wanted to inquire of?
No.
Mr. Thompson, as a friend of the court, I know I've placed you in a very difficult position. Is there anyone that you might want to question as a friend of the court?
No, Your Honor.
Right. Mr. Wilkins, as I advised you yesterday, sir, your disruptive behavior was challenging your ability to continue to represent yourself. You've been checked out by trained deputies who are medics. You've been checked out by a registered nurse as well as an emergency medical technician, all of whom indicate that there is nothing physically wrong with you, nor any reason why you couldn't continue here, sir. As I told you, sir, your constitutional right to represent yourself is not a license to abuse the dignity of the courtroom. Neither is it a license not to comply with the rules of procedure, the substantive rules, and it sounds like you're doing exactly what the witness indicated, Mr. Prigmore indicated you said you would do, which was to make some effort to cause a mistrial. But as I advised you, sir, and as the case law is very clear about, your behavior will not cause a mistrial. It certainly may have an effect on the jury. Sir, in 5 minutes I'm going to start again, with or without you. And if it's without you, it's because it's your choice, sir. I'm going to be back in the courtroom in 5 minutes. You can let me know if it's your choice to continue to participate, or if not, sir, if you cannot comply with the basic rules of courtroom dignity, then you will be removed from the courtroom, sir. I will advise the jury that it is your choice not to be present, that you are physically capable of being present, that you have been checked by medics who have indicated that there is nothing wrong with you or nothing that would prohibit you from continuing, and that this is your choice. And I will continue with closing arguments from the state, and I will assume then, sir, that you have waived your right to a closing argument. Anything further at this time, Mr. Brandt?
From the state, Your Honor.
Mr. Thompson, as a friend of the court?
No, Your Honor.
Mr. Wilkins? 5 minutes from now, I'll start again. Thank you.
Despite these disruptions, the trial proceeded, and Wilkins was convicted again, receiving a 42-year sentence. Next, we head to the Clay County Circuit Court, where Judge Shane T. Alexander presides over the case of 39-year-old Sean Pernice, who murdered his wife and then disposed of her body with the trash, likely sending her remains to a landfill. Sean Pernice, a Missouri firefighter with the Kansas City Independence Fire Department, had also served in the National Guard and the Army in Iraq. Outwardly, he seemed like a normal husband to Renee Pernice, a 35-year-old nursing instructor who had 3 children with him. However, their marriage was falling apart, and Sean was preparing to move out due to their impending divorce. On January 2, 2009, the couple argued at their Northland home after Renee discovered Sean had allegedly stolen $180 from her sister during a family Christmas party. In his anger, Sean struck Renee on the head, causing her to fall down a set of stairs and sustain fatal injuries. Despite being a trained paramedic, Sean did nothing to help her, and instead disposed of her body with the trash. This meant her remains were likely lost in a landfill. Renee was reported missing, and her cell phone was found 15 miles from her home days later. Sean refused to cooperate with the police search, and although foul play was suspected, there was no direct evidence linking him to the crime. After Renee's disappearance, Sean was arrested twice, once for allegedly stealing a neighbor's weapon, and again for disturbing the same neighbor after a 4th of July party. In 2010, he was formally charged with first-degree murder. Sean pleaded not guilty, with his mother, Masha Pernice, asserting his innocence and claiming Renee had left town after asking for a divorce. In February 2012, 3 years after Renee's death, Sean finally pleaded guilty to her murder. At his sentencing, he appeared emotionless as he briefly addressed the court, saying, "I'm sorry for the act I committed on January 2, 2009. Renee was a good mother, a good wife, and a good person. I snapped that day and wanted to hide it from my children." He also pleaded guilty to 2 counts of second-degree endangering the welfare of a child. After hearing emotional testimonies from Renee's family and friends, Judge Alexander sentenced Sean to 15 years in prison for voluntary manslaughter and 6 months for each endangerment charge. As the judge read his verdict, Sean showed no visible emotion about his lengthy prison sentence. This video is from a courtroom in Ohio. It shows Christopher Lee Ruffin, who had just been sentenced to 90 days in jail. Thinking the sentence was too harsh, he decided to escape. He managed to run out of the courtroom, even hijacked a car, but was eventually caught and brought back to jail. Despite several officers trying to catch him immediately, he was initially too quick for them. This footage highlights how unexpectedly eventful and seemingly easy it can be to escape from a courtroom. 3 men were arrested and charged with multiple crimes after a 4th man was found dead and his body stored in a refrigerator. One of the primary suspects, 27-year-old Austin McLeod, a wildland firefighter, along with the other 2 suspects, was found guilty by a jury on 4 out of 5 charges, including murder related to a botched robbery. On September 25, 2021, Austin McLeod, then 25, his brother Dylann McLeod, 22, and their friend Bryson Schofield, 20, invited 24-year-old Aaron Stitt to Schofield's apartment. While the nature of Stitt's relationship with the trio was unclear, investigators believe he was invited with the intention of robbery. Things went horribly wrong when Schofield ended up beating Stitt to death with a hammer and stuffing his body into a refrigerator. Police responded to a 911 call around 11:30 a.m., reporting an alleged assault, possibly involving a weapon. Upon arrival, they saw a young man running back into the apartment complex, who later turned out to be Schofield. The officers found Stitt's corpse inside the refrigerator and detained Schofield. Austin McLeod, possibly feeling guilty, had called the police to report the homicide. He and his brother were also arrested. During the trial, McLeod's defense team admitted his guilt in tampering with evidence and abusing Stitt's body, but denied involvement in the murder or robbery. You are not going to hear any evidence whatsoever that Austin McLeod even laid a finger on Mr. Stitt while he was still alive, stated one of his defense attorneys. In contrast, prosecutors argued that McLeod was aware of the robbery plan and was complicit in the crime, including hiding the body. A cell phone video showed Schofield discussing the aftermath of the murder with the McLeod brothers. Austin McLeod was set to be sentenced on May 12, 2023, and before the sentencing, he read a statement to the judge, pleading for a lighter sentence by detailing his role in ensuring Schofield's arrest.
Due to my actions in calling the police and reporting the homicide of Aaron Stitt, the police have his murder in custody, and that no one else was killed by Bryson Schofield.
However, this plea did not influence the judge and jury's decision. According to Jackson County District Attorney Beth Heckert, each defendant shifted blame onto the others for the crime. Austin McLeod was sentenced to life in prison with a minimum of 25 years before he can apply for parole. As the judge delivered the verdict, Austin McLeod showed no visible emotion. Dylann McLeod's trial is set to begin in August, and Bryson Schofield's trial is anticipated to start in October. Let's explore the story of Maurice Mom Boucher, a notorious former leader of the Hells Angels gang in Quebec, Canada. Boucher is well known for his violent crimes, including murder. He's been serving a life sentence since the 1990s for ending the lives of 2 prison guards in 1997, and he also received an additional 10-year sentence for being part of a murder conspiracy. In the 1990s, during a violent conflict between the Hells Angels and the Rock Machine gang, Boucher ordered the random murders of 2 correctional officers, Pierre Rondeau and Diane Levine. He aimed to make the act so shocking that the police would think twice about using biker gang informants. Although initially acquitted of these charges in 1998, an appeal court overturned the acquittal after finding out that the jury had been threatened, leading to Boucher's rearrest and subsequent conviction. A key testimony in his conviction came from a police informant, Stephen Gain, who had been instructed by Boucher to carry out the murders and got a 7-year deal for his cooperation. Financial records revealed that in just 8 months of 2000, the Hells Angels made over $11.5 million in Quebec. After 11 days of jury deliberation, Boucher was found guilty of 1 count of attempted murder and 2 counts of first-degree murder, leading to 2 life sentences, though he barely reacted to the verdict. Despite being in Canada's only supermax prison, Boucher continued his criminal activities. He tried to arrange another murder through his daughter, Alexandra Boucher, targeting a man named Raoul Desjardins. The plot was uncovered, and Boucher was charged again with conspiracy to commit murder. Surprisingly, he pleaded guilty immediately and received another 10-year sentence, showing little concern for the additional time. When the judge, Eric Dussault, asked Boucher to confirm his guilty plea, he loudly declared himself guilty. He chose to stay silent when offered a chance to speak in court, simply stating, "All is good." The judge noted Boucher's indifference to rehabilitation, emphasizing that his plea didn't show any real remorse. Boucher's reputation as a fearless criminal was underscored by a photo taken at the funeral of a fellow Hells Angels member where he boldly flashed a peace sign, showcasing his defiance and notorious nature. Next, we have the intriguing case of Joyce Mitchell, a prison worker who helped 2 inmates escape from an upstate New York prison. Joyce assisted prisoners David Sweat and Richard Matt, helping them escape in a way that reminded people of the movie Asterisk, The Shawshank Redemption Asterisk. She was charged with criminal facilitation and promoting prison contraband. The dramatic events even inspired a mini-series called Asterisk Escape at Dannemora Asterisk, which won a Golden Globe. Joyce reportedly smuggled chisels, hacksaw blades, and other tools into the prison inside frozen hamburger meat. She gave the meat to a guard to deliver and also provided 6 hacksaw blades to Richard Matt. The story also included allegations that Joyce performed favors for one of the men, though Joyce denies having intercourse with them. An inmate claimed Joyce and the men would disappear into a room for long hours, leading to jokes about them being a couple. Joyce has said her main reason for helping them was that they allegedly threatened her family, especially her husband.
I did wrong. I deserve to be punished. But, people need to know that I was only trying to save my family.
The inmates used power tools that Joyce smuggled in to cut through the backs of their cells. They broke through a brick wall and cut open a steam pipe, then crawled through it. Later, they emerged from a manhole to make it look like they were still in their cells. They arranged clothing and a hoodie inside their sheets and left a note that read, "Have a nice day." Joyce had planned to pick them up on the outskirts of the prison with a getaway car, but she didn't show up. Instead, she went to the hospital for a panic attack, forcing the men to regroup. Their escape led to a statewide search that lasted for days and caused a major stir in the state.
Don't know if they are still in the immediate area or if they are in Mexico.
Finally, after 3 weeks, they were caught. Richard was fatally wounded by authorities, while David was injured and arrested at the Canadian border. Joyce pleaded guilty, and the judge had this to say during her sentencing.
Mitchell, I just don't find that explanation credible. Your husband's life would not have been more endangered by exposing the plot to escape.
The judge continued by reprimanding Joyce, stating that her claim that the plea deal was too harsh was incorrect.
While you express remorse for the harm you caused the community, you also stated that you believe the negotiated sentence is too harsh. Taking into consideration all the various sentencing factors, I can assure you, you have nothing to complain about with the negotiated sentence. For the reasons stated, I will approve the sentence and proceed as follows.
With tears in her eyes, Joyce Mitchell was sentenced to 2 1/3 to 7 years in prison and fined $5,000. Denise Prell, hired around the same time as Joyce Mitchell, ended up in a similar situation. About a year into her job, Prell began a relationship with an inmate. This led to her firing and charges, including 1 count of second-degree promoting prison contraband, 1 count of third-degree sexual abuse, and 23 counts of official misconduct. Court documents showed that Prell and the inmate fell in love, communicating through letters under aliases Gwen Freeman, with Gwen from Gwendolyn, Prell's middle name, and Freeman symbolizing the inmate's hoped-for release. Their relationship grew to include phone calls, with Prell buying a phone for the inmate from Walmart and depositing $350 into his prison account. They even planned a future together after his release. The affair came to light when another corrections officer discovered the illicit relationship, leading to an investigation by the State Department of Corrections and Community Supervision and the Clinton County District Attorney's Office. Evidence confirmed their intimate relations. Initially, Denise Prell pleaded not guilty to all 25 charges.
Your Honor, she would waive a formal reading of the charges and enter a not guilty plea to all 25 counts.
Denise Prell's lawyer planned to file a motion to reduce the charges against her. However, before her trial began, she was granted bail.
A $5,000 cash bail, and the people have no objection to that continuing. She's made every court appearance.
As the case progressed, the prosecution offered Denise Prell a plea deal. Under this deal, she would plead guilty to a felony count of promoting prison contraband in exchange for a lighter sentence.
I don't think that charge is supported by any of the evidence that I've seen, even taking everything that's been said as true. And we're certainly not doing that either. So we rejected it.
This case gained high-profile status, especially because of the facility's notorious past with illicit affairs and jailbreaks. The attention was so great that then-Governor Andrew Cuomo even commented on the charges.
You run a system this large, obviously you're going to have deviations. The question is, do you have the systems in place to catch them and resolve them? And that's exactly what we did here.
During her sentencing, Denise was emotional and moved to tears. She was sentenced after accepting a plea deal and pleading guilty to the charges.
Your criminality in this matter, which you've pled guilty to, is difficult, if not nearly impossible to understand in light of what this community went.
Denise was sentenced to spend 1 year in prison. Welcome to Hillsborough County Courthouse. Stephen Lorenzo, a 64-year-old murderer, is known for his horrific crimes that terrified the Tampa community. He was charged with drugging, torturing, raping, and dismembering 2 men. The murders of 26-year-old Jason Galehouse and Michael Wachholtz shocked the Tampa Bay area. Lorenzo, along with his accomplice Scott Schweikert, abused, drugged, raped, and took the lives of the 2 men after leaving a Tampa nightclub in 2003. Lorenzo claimed they had planned to partake in substances and engage in group activities with 2 other men interested in bondage. He said he was a bondage master and that Schweikert wanted to become one as well. They convinced the men to participate in a bondage video, but things went wrong. Lorenzo said they put a gas mask on Galehouse because he didn't want to be identified in the video and feared he would call the police. They decided Galehouse couldn't leave and later dismembered him in Lorenzo's garage using an electric saw. The body parts were bagged and thrown in trash bins, and his remains were never found. Wachholtz's body was put in the back of his Jeep Cherokee and left at an apartment complex. DNA from both men was found in Lorenzo's home and garage, along with photos of men who were bound and beaten, including one of Wachholtz unconscious on Lorenzo's living room floor. The murders and other disappearances in the Tampa Bay area, along with confessions from others he had assaulted, led to fears of a serial killer targeting the gay community. In 2003, Lorenzo was charged and found guilty in federal court for using GHB in his crimes. He initially pleaded not guilty, but later, 19 years after the crime, filed a 147-page letter asking for the death penalty. Lorenzo made a surprise guilty plea to 2 counts of first-degree murder and chose not to have a jury decide his fate or present any evidence against capital punishment. He simply wanted to die. The judge accepted his plea after deciding it was made voluntarily and with understanding. Reports showed that Lorenzo had obsessive-compulsive disorder, hypersexuality from a brain injury, and signs of fetal alcohol disorder. He also had a history of childhood and adult abuse. The judge found some of this information credible, but did not think it was enough to avoid the death sentence. During the hearings, Lorenzo chose to represent himself, a common choice among serial killers. The judge commented on this decision.
Mr. Lorenzo, you've represented yourself pro se in these proceedings throughout, and we've had several discussions. The rules require that at every important stage of the proceedings that I reoffer you counsel. You are to be sentenced this morning. I believe that that is a very important part of your proceedings.
The judge offered Lorenzo legal counsel one more time before sentencing.
Would you like for me to appoint Mr. Gonzalez to represent you today before I announce the sentence in your case?
Excuse me, no, I'm fine, thank you.
All right. I just wanted to make that offer to you.
Gotcha.
Are you then representing yourself pro se, ready to proceed this morning?
Yes, most definitely.
As sentencing was about to begin, Lorenzo raised his hands and asked for 5 minutes to speak with the judge in court. Before making his request, he thanked the judge politely for overseeing his case.
And to the judge, I want to thank you because you have had incredible tolerance and patience and fairness to me while I stumbled my way through this whole process. And I want to appreciate that. I want you to know that, and I want that on the record for the Florida Supreme Court.
He then requested the death penalty, saying it would be more comfortable for him as an old man than spending his life in the federal prison system.
I'm seeking the death penalty. It's in my best interest, basically, because it's a comfort. I'll be living a lot more comfortable than I would in the federal system, living on death row, believe it or not.
He compared the death sentence to euthanasia, saying that everyone has a death sentence from the moment they're born, and that the judge would only be speeding up his inevitable death by sentencing him to death row.
So I'm asking you to give me the death sentence, because that'll be more comfortable for me to live out my lifetime. I know I can be on death row for about 10 or 15 years, which I think is crazy. But as far as I see it, it's just euthanasia. I already have a death sentence. Everybody in this room has a death sentence.
He then gave an unusual reason for wanting to be on death row. Stephen Lorenzo believes that when he dies, he will reincarnate and come back in another body.
The sooner that I get euthanized, as far as I'm concerned, the faster I can get, the sooner I can get, fetch myself a new body and come back again, a fresh body. That's how I look at it, because that's how it is. That's how spiritual work. We're eternal beings. So the way I look at it is, the sooner I euthanize, the sooner I can come back.
The judge, surprised by the man's request, wondered if it was some kind of reverse psychology. Despite this, he remained steady in his sentencing.
Thank you. And I don't know if what you say is perhaps some form of reverse psychology, nor do I care. I will not consider what you want in issuing my sentence.
I know that, yes.
All right. So I am then ready to proceed. Did you have anything else that you want to say?
No, I'm pretty good. I'm looking forward to getting this over.
The judge briefly continued with the sentencing.
I sentence you, Mr. Lorenzo, to death. That is the punishment that you deserve for these horrific crimes.
The judge sentenced him to death and ordered his transfer to the Department of Corrections for execution. Next, we have the case of George Tiafe, a former Las Vegas firefighter who was found guilty of murdering his wife with the aid of a homeless man. Shauna Tiafe, a 46-year-old cocktail waitress and mother, was brutally attacked on September 29, 2012, and died from injuries inflicted with a hammer. Initially, it appeared to be the work of a stalker or robber, but the true perpetrator turned out to be Shauna's husband, George Tiafe. George, a 43-year-old firefighter and West Point graduate, was living separately from Shauna due to their troubled marriage, which was heading for divorce. Shauna had moved to a separate apartment in Summerlin, though they shared custody of their 8-year-old daughter, Madison. George, known for his verbal abuse and manipulation, hired his homeless friend, Noel Greyhound Stevens, to end the life of Shauna. On the day of the murder, while Madison was at her grandmother's house, Stevens went to Shauna's apartment and waited for her to return from work. When she arrived, Stevens attacked her with a hammer, causing severe injuries, including a broken hand and deep wounds to her head. George then picked up Madison and took her to the apartment, where he discovered Shauna's body, and called 911. Initially, George seemed to have a solid alibi, claiming he was working a 24-hour shift at the fire station. The case took a turn when maintenance worker William Penix reported that Stevens had bragged about the murder. The police tracked down Stevens, who initially denied involvement, but later confessed. They found Shauna's bloodied underwear in Stevens' tent and uncovered numerous phone calls between Stevens and George before the murder. Surveillance footage also showed the two at a hardware store buying hammers. Stevens revealed that George had paid him only $600 of the $5,000 agreed upon for the hit. George was arrested after attempting to drive through a hospital barrier, possibly in a bid to end his life. He faced charges of first-degree murder, robbery, burglary, and conspiracy. During sentencing, George wrote about a vision or hallucination of his deceased wife comforting him and assuring him that everything was all right. Despite these claims, the judge sentenced George to life in prison without parole.
Having found the defendant, George M. TFA, guilty of count 7, first-degree murder with use of a deadly weapon, impose a sentence of life without the possibility of parole.
He was also sentenced to an additional 81 years on top of his life sentence for orchestrating the murder of his wife through a homeless accomplice. As the judge delivered the verdict, George TFA maintained a blank expression, seemingly resigned to the outcome. A few years ago, a woman in Kentucky was arrested and horribly mistreated by jail staff. She wasn't given pants or feminine hygiene products and was even taken to court without any trousers. The female judge who saw her was shocked by how she was treated. She immediately picked up the phone to complain about the prison workers.
Excuse me? This is outrageous. Is this for real? Our jail for 3 days, and it reports to me that the jail has refused to give her pants and feminine hygiene products.
She expressed her frustration about the incident.
What is this? Am I in the Twilight Zone? What is happening?
The judge was so upset about the woman's mistreatment that she gave her a lighter sentence. She stressed that everyone deserves dignity, even those who have broken the law. Quantrill Schwartzlow's escape is an interesting story. It happened at a sheriff's office. Schwartzlow was a suspect in a case where someone got seriously hurt, so he was brought to the Rock County Sheriff's Office in Janesville, Wisconsin. He was handcuffed and left alone in the interrogation room. The police didn't expect Schwartzlow to open the window while still handcuffed. It's surprising that he went straight for the window as soon as the detective left the room. After jumping out, he ran away. When the detective came back 14 minutes later, he was shocked to find Schwartzlow had escaped. Schwartzlow was caught again 3.5 hours later, hiding at a friend's house. Because of this escape, the police station updated their security by replacing the old windows from the 1980s with stainless steel security screens. This incident showed how far someone might go for freedom and the need for better security in detention facilities. This video shows female prisoners leaving a courtroom and heading to a bus that will take them to prison. Watch the two women at the end of the line, Tracy Mobley, charged with theft, and Mari Morrissey, charged with drunk driving. They had planned to escape and move to the back of the line. While their legs are not restrained, their hands are handcuffed. They sneak under the bus and cling to it as it starts to drive away. When the bus stops at a red light, they make their move and manage to break free from their handcuffs. Mari runs down the street right past the courthouse, but a private detective in a car spots her. He gets out and chases her off camera. Tracy is caught by an off-duty policewoman. Both women are returned to the courthouse and receive additional charges for trying to escape, but their plan ultimately fails. In 2009, a convict in Washington state and a judge clashed during sentencing. Judge John Wool first asked Matthew Hastings, "Did you graduate from high school?" implying that he was questioning Hastings' intelligence. When Hastings replied no, he became upset and started to get angry with the judge.
Okay, let me give you a little thumbnail sketch of the American system.
That's when the judge says, "Mr. Hastings, don't push your luck with me, young man." But Matthew responds exactly as the judge feared, asking, "Or what?"
Oh, press your luck
Or
with
what? You gonna sentence me? Is that what you're gonna do?
You know what, Mr. Hastings, I am.
Okay.
Let me tell you what.
The judge then sentences him to 120 years in prison.
I don't really want to care why. Just get on with
You
the
shut your mouth, sir.
The judge even adds that he might have Hastings gagged.
My mouth.
Next time, I'm going to have you gagged.
You're gonna have me gagged, huh?
You're right, I am.
Okay. Have me gagged then.
Even after receiving a 120-year sentence, Hastings continued to provoke the judge and irritate him. After the court hearing ended, the judge apologized to anyone who might have been offended by his earlier comment to shut your mouth. It's clear that both were trying to get under each other's skin. Do you think the judge should have acted this way? Personally, I think his reaction was justified given the circumstances. This is a story from Judge Rinder, a judge in the UK. One day, a defendant gave a really bad excuse for what they did. That's when Judge Rinder said, "I'm getting ready to laugh."
I'm getting into my laughing pose.
He then struck a pose for a moment before shouting, "Moron!"
Moron!
It might be unprofessional, but it's funny and made the court laugh. Sometimes it's refreshing when judges speak like regular people. Even the defendant, who was called a moron, seemed to find it amusing. In a case that deeply disturbed the community, Alfonso Alarcon Nunez, an undocumented Uber driver, faced serious charges of rape and burglary. The incidents occurred in San Luis Obispo, California, where Alarcon Nunez allegedly targeted vulnerable, intoxicated women seeking Uber rides. He was accused of assaulting and robbing several women who had ordered or were picked up by him. The charges included rape of an intoxicated person, and first-degree burglary. Prosecutors revealed that Alarcon Nunez would drive these women to their homes, enter their residences to commit assault, and then steal their personal belongings. He often frequented clubs and specifically targeted inebriated women, making it easier for him to pose as their Uber driver.
They called for an Uber and did exactly what they should do, and they got absolutely victimized and taken advantage of by this.
Even more alarmingly, Alarcon Nunez used victims' Venmo accounts to debit fares, bypassing the usual Uber payment process. He operated under several aliases, including Bruno Diaz and Brushbat Alarca. His connection with the victims came through his work as an Uber driver in Santa Barbara and San Luis Obispo, and investigators suspected there might be more victims in these areas. After his arrest, Alarcon Nunez pleaded not guilty to all charges during his arraignment at San Luis Obispo Superior Court. Initially granted bail at $200,000, the amount was later raised to $1.47 million due to the seriousness of the accusations. During the trial, 2 of his victims gave powerful impact statements, sharing the trauma and lasting effects of his actions. One victim expressed her hope that her words would convey her ongoing suffering, stating, "I'll never be able to live the life I once knew. I'll always live the life of a survivor." Alarcon Nunez, using an interpreter, remained silent throughout the trial, showing no remorse, which only added to the pain experienced by the victims and their families. He was found guilty of 13 felonies, including 3 counts of rape. Superior Court Judge Craig Van Rooyen sentenced him to 46 years to life in prison, plus an additional 8 years and 8 months, totaling 54 years and 8 months. In the aftermath, both law enforcement and the prosecution emphasized the need for better driver screening processes for rideshare companies like Uber. District Attorney Dan Dow called for enhanced measures to ensure passenger safety, advising Uber users to verify their driver's information before getting into the vehicle.
Mr. Alarcon Nunez is an undocumented immigrant here in the United States, a citizen of Mexico who was deported voluntarily in 2005.
While Alarcon Nunez's undocumented immigration status was noted, it was emphasized that this would not affect the prosecution. The focus remained on the seriousness of his crimes and ensuring justice for the victims. In response to these heinous acts, Uber expressed deep concern and committed to fully cooperating with law enforcement. The company permanently removed Alarcon Nunez from its platform and supported the investigation. Uber spokesperson Andrew Hasbin affirmed the company's dedication to user safety and preventing such incidents in the future. He stated, "What police have reported is absolutely horrifying and something no person should ever have to experience." Next, we turn to the sentencing in the controversial case involving an Uber driver who fatally harmed a BLM protester. Daniel Perry, an Army sergeant, was charged in a Texas court for the murder of Garrett Foster, who was a protester in 2020. The incident occurred during a protest against police brutality and racial injustice in downtown Austin. Perry drove his car into a group of protesters and fired at Foster from his car window. Foster, a supporter of the BLM movement, had been participating in the protest with his girlfriend for 50 days. After the incident, Perry called 911 to report the incident. During the trial, the jury saw body camera footage of the aftermath, where a police officer described Perry as visibly shaken by the event. Perry told authorities that protesters had attacked his car, leading him to accidentally drive into the crowd.
There looked to be like boot or
kick marks along the vehicle, and then I observed what I felt was, at the time, 2 bullet holes in the vehicle.
Perry claimed that Foster was armed and that he initially rolled down his window because he thought Foster was going to speak to him. However, court records later revealed troubling details about Perry's social media activity and communications leading up to the murder. Unsealed by a Travis County district judge, these records showed Perry's online searches related to the protests and his interactions with racist content, including comments and memes. Additionally, Perry had discussed buying more ammunition with an acquaintance and expressed his willingness to harm or use lethal force against people if they attacked him or tried to remove him from his vehicle. In a June 2020 message to a friend, he said, "I might have to kill a few people on my way to work. They're rioting outside my apartment complex." He also mentioned considering going to Dallas to harm looters in another post. The most incriminating evidence came from a Facebook message to his friend Michael Holcomb, where Perry discussed how he could justify harming a protester using the stand your ground defense, arguing that it would be legal if done in self-defense. This conversation took place just 2 weeks before Perry harmed Garrett Foster.
Conversations with Michael Holcomb are starting to look like a playbook for what you would do if you wanted to use force in these situations.
The records also revealed Perry referring to himself as a racist and showing frustration with protesters, making his situation look even worse. Perry's defense team argued that he acted in self-defense, claiming that Foster approached his car while holding an AK-47 rifle.
Legitimate self-defense. Daniel Perry had 0.2 of a second to decide what he had to do.
Close your eyes and picture that. And as you're picturing that, picture this.
However, witnesses contradicted Perry's account, stating that Foster never pointed his weapon at him. Perry, stationed at Fort Hood and working for Uber in Austin, was seen on a live Facebook stream where sounds of firing were heard, causing chaos among the protesters. Prosecutors had requested a minimum of 25 years, while Perry's defense team sought a 10-year sentence. The sentencing hearing was contentious, with debates focusing on Perry's racist social media posts and text messages, as well as his psychological state. Perry's defense attorneys argued that his posts and comments were either irrelevant or misinterpreted, trying to downplay their impact. In contrast, the prosecution portrayed him as a potential threat, citing his mental health issues and military training as contributing factors. In May 2023, a Texas judge sentenced Perry to 25 years in prison.
This court sentences you to a term of 25 years in the Texas Department of Criminal Justice.
Perry was visibly emotional during the sentencing, crying and being comforted. After Perry's conviction, Texas Governor Greg Abbott announced his intention to pardon Perry. In a tweet from his official Twitter account, he stated, "I am working as swiftly as Texas law allows regarding the pardon of Sergeant Perry." Governor Abbott's involvement stirred controversy, with conservatives criticizing the conviction and advocating for a pardon. Despite the uproar, Foster's family expressed satisfaction with the court's decision. In Michigan, the case of Jason Dalton unfolded. Dalton, an Uber driver from Kalamazoo, Michigan, pleaded guilty to the horrific crimes he committed during a violent spree in 2016. He faced 16 charges, including 6 counts of murder, 2 counts of attempted murder, and 8 counts of using a firearm during a felony. The violent spree took place on February 20th, 2016, when Dalton, with no prior criminal history, ended the lives of 6 people and injured 2 others while driving his Uber vehicle. Alarmingly, he picked up passengers between the attacks, showing a chilling calmness amid his violence. Dalton later told detectives that he believed the Uber app had turned him into a puppet, suggesting it made him commit the crimes.
I can't believe in this, but it literally took over mind and body.
The Uber app?
Yes. It was red when I first started. I switched from red to black. When it's in that black mode, it literally has control of you.
The incidents happened at 3 different places in Kalamazoo. Dalton's first victim was Tiana Carruthers, a 25-year-old mother who was injured while trying to protect a group of children near her home. Although she survived, she was badly hurt. Dalton went on to harm Barbara Hawthorne, 68, Mary Jo Nye, 60, Abigail Kopp, 14, Tyler Smith, 17, Mary Lou Nye, 62, and Dorothy Brown, 74. He targeted Richard Smith and his 17-year-old son, Tyler Smith, who were just looking at cars at a dealership. The violent spree ended at a Cracker Barrel restaurant, where Dalton fired at Barbara Hawthorne, Mary Jo Nye, Abigail Kopp, Mary Lou Nye, and Dorothy Brown. While they were injured, they survived. After the attacks, there were concerns about Uber's role in keeping passengers safe. Matt Mellon, who had a close call with Dalton before the incident, sued Uber and Dalton, seeking to hold them accountable. The lawsuit claimed Uber didn't act properly on reports of Dalton's dangerous driving, leaving Mellon feeling deceived and powerless. It pointed out that Uber's 24/7 team was supposed to look into safety issues and deactivate dangerous drivers. Dalton admitted guilt before the trial started, even though his lawyer had advised against it. Dalton chose to plead guilty to avoid putting his own family and the victims' families through the stress of a trial. During the trial, Dalton heard the impact statements from the victims' families, but he showed no remorse, causing Tiana Carruthers to break down in tears.
I seen him coming. And I saw a gun.
But as Carruthers struggles to find the right words, Dalton interrupts her.
No, they gave bags. These old people, they have these old black bags. They're called they're black. They're black bags that people drive around and you look at.
He continues to ramble on, causing Carruthers to start tearing up.
Ms. Carruthers, are you okay? Or do we need to take a minute?
Eventually, Dalton was removed from the courtroom and sentenced to life in prison without the possibility of parole. Judge Christopher Henniker oversaw the case and made sure that justice was served for the lives that were lost and for the survivors who had to move on. In Las Cruces, New Mexico, at the 3rd Judicial District Court, 34-year-old Crystal Cardenas was sentenced for the murder of her ex-boyfriend, 34-year-old Mario Cabal, and his girlfriend, 32-year-old Vanessa Rodriguez Mora. The incident occurred on the night of March 25, 2018, and became known as the Garfield Killings. Cardenas, along with her then-boyfriend, 36-year-old Luis Flores, initially tried to hire a hitman to end the life of Cabal during a heated custody battle. When that plan failed, they decided to do the job themselves, resulting in the deaths of Cabal and Rodriguez Mora. During the attack, Rodriguez Mora's daughter hid in another room. The next morning, the daughter found the bodies of her mother and Cabal and ran to a neighbor's house to call the police. She testified that she heard sound of firing the previous night, but thought it was just a bad dream until she saw the bloody scene the next morning.
My mom was in the couch, just bleeding from her nose. And then I was like, Mom, wake up, and she didn't wake up.
The prosecution and defense lawyers fiercely debated the case of Crystal Cardenas in court. The district attorney presented the case built over the past 5 days, starting with events from the night of March 25, 2018, as described by Vanessa Rodriguez Mora's daughter. She testified that she was watching TV with her mom and Mario Cabal before going to sleep. Later, she woke up to firing, hid under a blanket, and eventually fell back asleep, thinking it was just a bad dream. The prosecution argued that further evidence and witness accounts revealed that Cardenas and her boyfriend, Luis Flores, had watched Cabal's house and waited until the couple was asleep to attack. Shortly after midnight, Flores entered the home, fired at Cabal once and Rodriguez Mora 3 times, before firing Cabal 6 more times in the groin, indicating a premeditated attack. The prosecutors also claimed that Cardenas initially tried to hire Edward Alonzo for the murder, agreeing to pay $110,000 but only giving him $3,000. Alonzo, arrested on another charge, disclosed the murder plot to reduce his sentence. He testified in court with his identity concealed, sharing details of the arrangement.
She had told me that if I wasn't able to finish the job, or for some reason it wasn't able to get done when it was going to get done.
Prosecutors claimed that Cardenas wanted the house that Cabal built after he received a large settlement, especially after they separated and he put the house in their daughter's name. They argued that if Cabal died, Cardenas could stay in his house because she was about to lose her own house due to financial problems. However, Cardenas' lawyer, Todd Holmes, suggested that the couple might have been targeted by a substance cartel. He also noted that there was no physical evidence like DNA or fingerprints linking Flores or Cardenas to the crime scene. He questioned the credibility of a key witness who said Cardenas hired him to end the life of her ex-boyfriend. Cardenas also consistently claimed she was innocent throughout the trial.
I was shocked. I was just shocked. I was shocked. I didn't believe it.
How was your mood?
Excuse me?
How was your mood about learning that information?
I started crying.
The prosecutor spent some time arguing against the idea proposed by Cardenas's lawyer that a drug cartel was responsible for the deaths of Cabal and Rodriguez Mora.
We find the defendant guilty of first-degree murder.
3 hours after both sides finished their closing arguments, the jury decided that Crystal Cardenas was guilty of first-degree murder, conspiracy to commit first-degree murder, and criminal solicitation. They did not find her guilty of the second-degree murder charge. Judge Conrad Perea of the 3rd Judicial District Court sentenced her to a total of 54 years in prison. Although the charge of capital murder typically results in a life sentence, Cardenas will have a chance for parole after serving several decades. Next, we'll head to Seattle for the sentencing of Rodney Lee Rollis, who tried his best to disrupt the court proceedings. Rollis was convicted for the 2001 murder of Michael Santa Walsh at a party in rural Snohomish County. Walsh, known for his white beard and playing Santa Claus for children with developmental disabilities, met a tragic end after Rollis and an accomplice discovered that Walsh had falsely claimed to be a Hells Angels member. This act led them to earn a filthy few patch, which indicates a willingness to commit violence for the club. Rollis was also accused of robbery, extortion, and murder. During his sentencing in Seattle, Rollis interrupted to complain about being treated unfairly. Prosecutors outlined his history of violent behavior, including a 2001 incident where he assaulted a 60-year-old man to steal Hells Angels items. That summer, he harmed Walsh and left his body by the road. The government also highlighted cases where Rollis stole motorcycles by threatening their owners. When a mentally disabled friend of one victim called the police, Rollis intimidated him into giving up his motorcycle. Prosecutors described Rollis as a petty and violent bully who was eager to join the Hells Angels and fiercely protect its reputation. They argued that Rollis and other members of the Seattle-based Nomad chapter acted criminally to preserve the club's image by punishing anyone who falsely claimed membership. After a 10-week racketeering trial, Rollis and 2 others were found guilty of 12 charges, including murder, conspiracy, and being part of a criminal organization. The use of the RICO statute, initially for targeting crime syndicates like the Mafia, was adapted for violent street gangs and organizations. Upon receiving a life sentence, Rollis voiced his anger, claiming the trial was unfair and accusing the judge of allowing false testimony from paid informants. He protested, stating he was unjustly convicted for standing up for his family and against corrupt police, calling it an illegal sentencing of an innocent man. However, any further complaints he had would have to be handled through the appeals process, as Judge Lasnik stated that these concerns would not change the sentencing outcome. This case happened in Florida, USA, in 2011. Margaret Allen was on trial for ending the life of her housekeeper, who she thought had stolen money from her purse. Things got out of hand, and she ended up strangling the housekeeper with a belt. Allen then tried to bury the body in a shallow grave. During the trial, she begged the judge to spare her life.
I know this has not been easy, but I want you to know that you are.
But the judge didn't accept her plea. Instead, she sentenced Margaret Allen to death.
He said, "Thank God that's over."
No, that's not true. I didn't do it.
In 2019, Margaret Allen tried to get her death sentence overturned, but a court upheld it. When she heard the decision, she sobbed and expressed her remorse, saying she was sorry for what she had done.
I know this has not been easy, but I want you to know that you are.
Despite her previous expressions of remorse, Margaret Allen later claimed she did not commit the crime. She argued that she should not be on death row because she was innocent. Nohema Graber, a Spanish teacher, was tragically slain by 2 of her students in 2022 in Iowa, USA. The incident reportedly happened in a park near the school, allegedly because one of the students was upset over receiving a bad grade. The students involved, Jaden Miller and Jeremy Goodale, both 17 years old at the time, faced court without showing any apparent remorse. This case starkly illustrates how a situation as common as a poor grade was misinterpreted as a life or death issue, leading to a senseless act that ended a life and irreparably altered their own futures. Next is the case of Jonathan Michael Hearn, a religious firefighter caught in a deadly love triangle. Hearn, a former Redlands firefighter, had a romantic relationship with Sabrina Lyman, an older married woman. The two often joked about her knocking off her husband, but this dark joke turned into a tragic reality. Today, Judge John R. Brownlee presides over this case in Kern County Superior Court, delivering justice as deserved. Hearn and Lyman's affair began when they met at Costco, where Sabrina worked part-time. Both were Christians, which facilitated their connection, but their affair took a dark turn when they plotted to end the life of Lyman's husband, Robert, so they could marry and raise her 2 children. Robert and Sabrina Lyman, known for their friendly demeanor and hosting lively parties, had opened their marriage to other couples in 2008, becoming swingers. Sabrina later grew weary of this lifestyle and wanted to return to a traditional marriage, but Robert refused. In 2012, Sabrina began an affair with Hearn, then just 22. When Robert found out about the affair through texts on Sabrina's phone, he demanded she end it, but she continued seeing Hearn. On August 17, 2014, Robert was fatally wounded at the BNSF rail yard in Tehachapi. Initially, his death seemed like a botched robbery, but detectives soon suspected foul play. Surveillance footage showed Robert and a man on a motorcycle at the scene. A tip from Jason Bernatine, a friend of the Lymans, led detectives to Jonathan Hearn, who had left a suspicious voicemail expressing remorse about Robert's death. Despite wiretapping Hearn and Sabrina's phones, no direct evidence linked them to the murder. Detectives fed Sabrina false information about the case, and she contacted Hearn with a burner phone to relay the details. Both were arrested on November 18, 2014. At Hearn's apartment, detectives found items matching the description of the motorcycle rider. Sabrina was released due to lack of direct evidence, but Hearn stayed in prison for 2 years. On January 6, 2017, Hearn agreed to a plea deal for a lesser sentence in exchange for testifying against Sabrina. During her trial, Hearn revealed their plans included poisoning Robert's banana pudding with arsenic and staging a car wreck or fire, but they ultimately chose to fire at him. On November 16, 2017, Hearn appeared in court for sentencing, visibly emotional even before the judge announced his verdict. He offered a tearful apology to Robert's family and friends.
I'm sorry for stealing your brother, your friend, your beloved relative, and taking your joy from you. I'm sorry for stealing and killing and destroying, for my senseless anger, for my blind violence, and for being so dismissive of Robert's marriage and his life.
Instead of first-degree murder, Hearn was convicted of voluntary manslaughter and sentenced to 25 years and 4 months in prison.
Pursuant to the plea agreement, it will be ordered that the defendant serve 25 years, 4 months in prison.
As the judge announced Hearn's sentence, he was seen with his head bowed, crying. On February 21, 2018, Sabrina was found guilty of the charges against her and sentenced to 25 years to life in prison. The trial of former South Korean President Park Geun-hye at the Seoul Central District Court involved charges of bribery and abuse of power, which reverberated through the nation's political and business circles. The scandal, rooted in Park's close ties with her advisor Choi Soon-sil, unfolded with accusations of cult activities, influence peddling, and the leaking of classified information. This controversy traced back to 1974, when Park assumed the role of First Lady after her mother was assassinated by a North Korean agent. Following her father's assassination in 1979, Park grew close to Choi Tae-min, a cult leader dubbed the Korean Rasputin, whose daughter, Choi Soon-sil, later became a key figure in Park's presidency. In February 2018, Choi Soon-sil was sentenced to 20 years in prison for corruption, influence peddling, and abuse of power. She had leveraged her relationship with President Park to extract millions in donations for her nonprofit foundations from major conglomerates like Samsung. Park was accused of conspiring with Choi and allowing her unauthorized access to confidential state documents. As the trial commenced in February 2018, prosecutors sought a 30-year sentence for Park. Her defense pleaded for leniency, citing her commitment to national leadership. Outside the courtroom, hundreds of Park's supporters rallied, claiming her innocence, while the Liberty Korea Party, which Park once led, criticized the severity of the proposed sentence. The scandal not only marked the downfall of South Korea's first female president, but also spotlighted the pervasive corruption linking the political and business elites, undermining public trust and igniting mass protests. It prompted calls for political and corporate reforms, emphasizing the need for transparency, accountability, and public engagement in governance. The ongoing effects of this scandal continue to challenge South Korea as it seeks to forge a fairer and less corrupt society.
Someone convicted of taking bribes of over 100 million South Korean won would be sentenced to at least 10 years in prison.
During her sentencing, Park Geun-hye appeared composed, showing no visible signs of remorse. Ultimately, she was found guilty and sentenced to 30 years in prison for her involvement in the corruption scandal, and she was also fined 118.5 billion won. In a case filled with personal turmoil, mixed martial artist Jonathan Paul Copenhaver, also known as War Machine, faced a major legal challenge in 2017. The trial centered around a violent 2014 attack on his ex-girlfriend. During the trial, she gave a moving testimony about the severe injuries she endured, including a broken nose, fractured ribs, and lost teeth. War Machine was sentenced to 36 years to life in prison. The harshness of the sentence triggered a strong reaction from Copenhaver, who became extremely angry and distressed. He even thought about ending his life, feeling crushed by the weight of his situation and the long prison term ahead of him.
There's no reason right now that I shouldn't be in the dirt right now.
Of course, with him being in prison, any thoughts of ending his life are not feasible. Thank you so much for watching. Don't forget to subscribe and hit the notification bell so you can stay updated with our latest videos.